Thanks everyone for coming. This is our fourth CPD in the series, and today Bilal and Robert have kindly agreed. Pull up a seat, Michael. Kindly agreed to speak on the topic of the intersection of law and religion, which has its own interests, of course. You've all got the paper, Matters Spiritual and Temporal, which has been distributed. I just wanted to start very briefly by explaining the constitutional setting that we find ourselves in, and that is section 116 of the Constitution, which strangely enough is found in chapter 5 under the heading the states, and yet section 116 applies to the Commonwealth only and doesn't refer to the states or have any application to them. And you might ask, why is that? Well, you have to have a bit of appreciation of the history and what happened way back in the constitutional conventions. So we start in 1891 in Melbourne, and there was a provision that the predecessor was in the place of, under the heading of the states, and it dealt with freedom of religion as it would apply to the newly formed states. There wasn't any mention of the Commonwealth because there is nothing in the enumerated powers in section 51 which gives Commonwealth Parliament the power to make laws in relation to that subject matter, being religion. So they thought there was no need to have anything by way of a protection in section 116 for that purpose. The other wrinkle in the story is that in the preamble, and it's still there, there is a reference to Almighty God. Now, some people, and especially H.B. Higgins, who you will all have heard about, he was the first president of the Conciliation Court, member for Geelong Richards football team, president of the Carlton Football Club, famous man in history. He didn't like the fact that Almighty God was mentioned in the preamble, and he came up with this argument based on a US decision from 1892 that the mere fact that God is mentioned in the preamble would be enough to give the Commonwealth powers to do certain things in respect of religions. For example, creating a Christian nation, which was never the intent. But nevertheless, Higgins was hell-bent in taking these words out of the preamble. So what he did by way of a strategy was to introduce a new version of section 116 that applied to both the states and the Commonwealth. And so there was a huge debate about this. People didn't think that there was any need for it to apply to the states. The argument went that the colonies already dealt with freedom of religion sufficiently, so there was no need for that. And of course, there was an argument about whether it should apply to the Commonwealth in circumstances where there was no enumerated powers. The argument then went, however, that the danger was that the Commonwealth might legislate with respect to weekend trading, Sunday trading on the Sabbath. And that was enough to scare people into having section 116 in the final form that it is. And that's why we see it in chapter 5 under the heading, the states. So there was never really any intent for it to be there to offer religious protection to the people of the Commonwealth in the form that it is. So what it did as far as content goes is basically pick up the terms from Article 1 of the First Amendment, the First Amendment to the US Constitution, and part of Article 1 of the Constitution itself. So there are two parts of the US Constitution which are now in section 116 of the Commonwealth Constitution. So what did it all mean? The first decision, there haven't been many decisions, and there weren't up until the Second World War. The first decision came just before the First World War in a case called Krieger, Krygger. And this was a young chap who, pursuant to regulations in the Commonwealth Defence Act, was required to present for military training. And he said, well, I believe in the scriptures, I've been taught to turn the other cheek in the face of my enemy, and therefore I have a religious objection to turning up to military training. This got to the High Court, and if you read it, it's a very short decision. They use language like the argument being absurd, Griffith actually said, I wasn't actually going to hear from the parties, but they seem to think this is a far more important matter than what I do. So they gave a very short shrift, did not think that the objections had anything to do with Section 116, and the case was effectively dismissed on that basis. The next decision, we had to wait something like 30 years into the next war period, and that was a decision involving the Adelaide chapter of the Church of the Jehovah's Witnesses. Now, the Commonwealth took the view that they were promulgating a religious doctrine which was undermining the war effort, because they believed that all secular governments were governments of Satan, and you can imagine they were going door to door and espousing these sorts of beliefs, and so the minister took a very harsh view about this, and pursuant to Defence Force regulations, he had the power to make a declaration which ended up seeing the Adelaide chapter being wound up and their assets seized by the government. So this got to the High Court, and they took the point under Section 116 that this was a direct interference with their freedom of religion to go around and espouse these types of views. And only one judge actually found that that was correct on Section 116 grounds. The rest of them did not. So the point to take away from that is that the freedom of religion in Australia is not an absolute right. They apply principles of proportionality to balance effectively whatever rights you are to find in Section 116 against legitimate objectives that you find in government legislation. So that's the constitutional framework up until a certain point in time. There are a few other cases, but I only really wanted to say something by way of introduction, and I will now hand over to Mr. Goot or Mr. Rauf.
Initially me.
Okay, Rauf, you're right.
Thank you, Tom, for requesting us to prepare this paper. I must say that I resented it initially because it was something that I didn't want to do, but Bilal, of course, loved to do it and to assist. But ultimately, I was grateful because it is actually quite an interesting exercise to discipline yourself to look at things and to prepare something for your colleagues, even though it might not be classified as riveting. And I also want to apologise for Max's appearance. No, he thought that being in this new environment, he could wear what he's wearing. But because he does get a mention in one of the cases, it was important that he came, and that's why he decided to come. We want to deal with two things this afternoon under the topic of matters spiritual and temporal. Firstly, an examination of some key cases dealing with the engagement of ministers of religion and staff in religious institutions, and the intersectional law of contract with that. And secondly, to briefly consider again the intersection of religious rights and legal rights arising out of the same-sex marriage discussion, and the question of religious freedom, which has been raised by the No case. Within the first topic, there are four cases. Bilal is going to deal with the first two, which relate to the intention to form or create contractual relations, and I will deal with the latter two. So it's over to Bilal.
Thank you. All right. Well, so turning to the first part of it, so I'll just look at the two key decisions on the question of the common intention to create legal relations in the context of ministers of religion, and I'll talk about the two cases, Ermogenous and also Redeemer. Redeemer, of course, being a case that Tom was involved in. And explore sort of the way, or the shift, if you like, in the manner in which certain presumptions have been applied and or operated. But if I could just go back a step to late 1990s in Ermogenous, there was, in respect of the employment of ministers of religion, there was a certain, or a line of cases, particularly UK and the US, and to some extent in Australia, whereby the starting premise really was that with ministers of religion, there wasn't any, or there was a presumption against any intention to create legal relations. And so that tended to be a bit of a starting point. And just to explain in terms of that requirement, now we're all familiar with the requirements relating to valid contracts, of course, one of them being that there must be a common intention to create legal relations or to be legally bound. So it was, and it's one of those sort of requirements which certainly in my experience, and depending on the work that you do, it's not one that tends to be scrutinised all that often, and that's because there are these certain presumptions which inform and guide, and unless a party is seeking to challenge or rebut the presumption, there tends not to be the same level of scrutiny. But in the context of ministers of religion, clearly it was an issue. So the historic sort of line of cases suggested that there was a presumption against there being any common intention to be legally bound. There was a decision then of the Industrial Relations Commission of New South Wales, Knowles, and the Anglican Church Property Trust Diocese of Bathurst in 1999, and that really sort of affirmed, if you like, or picked up this premise or view about there being a presumption against an intention to create contractual relations. And so Justice Wright, in referring to an earlier Court of Appeal decision in Scandrett and Dowling, he said this, and I'll just very quickly note this because I think it sort of explains really the thinking, but in citing the passage from that Scandrett and Dowling decision, which read as follows: in my opinion, the parties to the consensual compact upon which the plaintiffs rely are bound to it by their shared faith, not the availability of the secular sanctions of the judgments, orders or decrees of state courts of law. The belief of church members is that they are all one in Christ Jesus. An acceptable way of describing the church, as I understand it, is that it is constituted by this unity. The consensual compact is thus based on religious, spiritual and mystical ideas, not on common law contract. It has the same effect as common law contract when matters of church property become involved, with the other matters dealt with by the conceptual compact. I do not think the claims made in this case get out of the area of the consensual compact. So really sort of highlighting that fundamentally, in terms of the engagements of ministers of religion and staff of religious institutions, etc., there was an overriding view that it was more along spiritual lines and not subject to secular law or enforcement in courts of law. Where that changed was the Ermogenous decision, and so this was a decision of the High Court in 2002, where, just to set the scene, so it was concerned the Archbishop of the Greek Orthodox Church, and who had been engaged for more than 20 years servicing the community, and he was recruited by the community, if you like, to provide the spiritual needs and service those needs. He was subject to the directions of the officers of the administration, and but the community itself, as it was defined, or the employer in this case, its matters were not just confined to religious issues, but also property and other social and cultural activities as well. So he resigned and then made a claim for sums due by way of leave entitlements under a contract pursuant to the Industrial Arbitration Act of South Australia. So, and it was in that context that the matter came before the industrial magistrate, who at first instance found that there was an employment relationship and that there was a contract in place which was enforceable and that the entitlements flowed from it. So he was able to recover the benefits. And there were various sort of appeals, and it was on the third appeal that the industrial magistrate's findings were overturned, and then leave was sought and granted from that to take it to the High Court. Now, there has been a paper circulated, and as Robert mentioned, it is a little bit dense in terms of the topic, so I'm trying to sort of skim through it. But we have set out in far more detail the various findings and other views expressed in that paper. So if it does trigger a deeper interest, I urge you to read it and refer to it. But just coming back to the High Court's analysis of this issue about the presumption again. So whereas the industrial magistrate wasn't too troubled by that, he looked at it and looked at the circumstances, the manner of the engagement, the fact of the Archbishop being paid a regular amount and being referred to, in effect, as an employee, and amounts then remitted to ATO, etc. So even looking at the common law sort of multifactorial indicia to employment relationships, it sort of ticked those boxes as well. And the industrial magistrate wasn't too troubled in arriving at the view that there was a contract and that relevant entitlements were able to be recovered. But the at the third on the third appeal, the full court at that stage formed a view that, well, look, no, hang on, there's no common intention to be legally bound here, and that's the starting point. Need to look at that, and then that sort of morphed into a discussion about a presumption against common intention in the context of this case. And so the High Court really started there, looked at that, and it rejected the notion that there could be no binding agreement for an employment of a minister of religion. And it referred back to the industrial magistrate's views, and Kirby sort of summarised in his decision, so there was a majority, but Kirby had his own decision coming to the same view, but he summarised the challenge, if you like, as amounting to, in effect, an argument that the arrangements made for sustenance and similar benefits with a minister are not ones that the law treats as justiciable, therefore, in effect, outside of the scope of enforcement and law. And he also looked at some of these UK and US authorities, and he, along with the majority decision, distinguished them on the basis of those other authorities in different jurisdictions having different histories and legal foundations as compared to the situation and the development of these things in Australia. So they were able to really differentiate that and come to the view that there wasn't, it shouldn't be understood, or the starting premise certainly isn't, that there is a presumption against there being common intentions in respect of the engagement of ministers of religion. and therefore, having regard to the circumstances, and it does require a scrutiny of that, there can flow from that the ability to enforce rights or entitlements, etc. And now that's to be contrasted, though, with a case, the other case I just wanted to quickly touch upon as well, which is the Redeemer Baptist Church and Glossop and others, 2006 decision. And that was a matter where, so this is the one that Tom was involved in, I think, and it was a matter where the plaintiff, the Redeemer Baptist Church, sued for defamation, but there was an important sort of criterion that it could only pursue that claim under the Defamation Act at the time if it could come within an exemption, and that is that if it employed fewer than 10 persons at the time of the publication of the matter. So the question, there was an initial consideration, well, did it employ 10 or fewer such that it could maintain its claim? And in looking at that, Justice Nicholas in that matter, he looked to the question of employment. But before I just come to that, if I can note at the outset, the judge was able to dispose of the matter on a different ground, namely that the use of the word employs in the context of this case was much broader than some industrial notion of employment. It extended to volunteers and others, and it wasn't to be understood in any confined way. So he was able to deal with it in that context, but nonetheless he did deal with an alternative submission of the plaintiff. And the alternative submission that was put was that the staff were, who were volunteers and ordained members of the ministry order of the Redeemer Baptist Church, they were not employed under contracts of employment. And it was argued that they did this on a volunteer basis, etc. And the circumstances of this matter were to be distinguished from Ermogenous, and indeed, in respect of this issue, that was the case. And the other important issue here was that as between the parties to the arrangement, there wasn't any assertion that there was a legally enforceable contract. Rather, it was a third person involved in the proceedings who was asserting that there was some contract at play, and the relevant staff who were undertaking work, teaching work, etc., were employed, and therefore the defamation cause of action could not be maintained. But so in considering that point, Justice Nicholas looked at the circumstances, and some of the distinguishing factors here were that there wasn't any agreed stipend or regular payment, and indeed there was a consensual basis upon which members combined to serve the church, and it was common ground as between those parties that there wasn't any contractual effect. And Nicholas summarised as follows, that the evidence was that stipends were paid at the discretion of the elders according to the needs of the member and the church's capacity to pay. Accordingly, any obligation was illusory in that it was unenforceable. Stipends were not calculated with regard to time spent working for the school or other ministries, or to the value of services provided. In my opinion, the evidence makes it very clear that the work of the teachers was not done in consideration of, or in return for, or in order to earn a stipend. And so His Honour found that overall the circumstances showed that the plaintiff teachers did not intend and could not be regarded as having intended that their relationship would be legally enforceable. So I suppose just in terms of the takeaway points there, twofold really. One is that these two cases make clear that certainly the starting point isn't that there is some presumption against there being a common intention to be legally bound when it concerns the employment or engagement of ministers of religion and staff. That said, there may be circumstances where, indeed, on an objective analysis of the circumstances, there is a common intention that there isn't any legally enforceable contract, and if that is the case, then the court will respect that, as it did in Redeemer on that point. But they're really the takeaway points as to the common intention point. I'll hand over to Robert to talk about the other two.
Can I just ask a question about this? Your paper raised, in my mind, an interesting question. It referred to the fact that in a religious type contract, as in any contract, it's open to the parties to include in that contract references to the laws of other countries or different
religious frameworks. Yeah.
Now, the question that raised in my mind was whether the ultimate question here is whether there's an intention to create legal relations per se, or whether there may be room for the question as to whether there's an intention to create legal relations in relation to the particular aspect of a transaction. So it raised in my mind the question of this question, whether there's room for the notion that in a situation where the court is quite satisfied where there is an intention to create legal relations and where there's nothing in the contract that actually stipulates otherwise in relation to any particular term, whether there's nonetheless room for a question of whether a particular term or terms or provisions within that contract are able to be defeasible because they relate to matters spiritual and not matters legal. Where does that debate lie? Where is the right question whether there is an intention to create legal relations at all, or is it another question?
About whether it's severable, really.
Correct.
We don't have an intention vis-a-vis X or Y, but we
Correct.
don't balance.
What's the question?
It comes within Robert's case.
I think I won't steal Robert's thunder, because that's precisely the point that arose in the context of the firstly the Goot decision, but then also the Southhead Rabbi decision, where there was a reference.
That question no real?
Well, I mean, there's the overarching, I think, the starting point being the general characterisation of the arrangement. What is that? What is that governed by? Is there some understood or clearly understood sort of arrangement, and then looking at the terms of that, I suppose, then it may be that it's a question of, as one may look at agreements with reference to aspirational or clearly defined sort of provisions that impose obligations, it might be that then when it comes to that third step of looking at the terms, it may be that does permit for such a distinction. Having said that, I suppose the other question, coming to your point about reference to external bodies of laws or ideologies or whatever it might be, how that sort of comes into the picture as well in terms of enforceability of a contract, and that's sort of precisely the point that arose in the case of the two rabbis. So I'll hand that. I'm going to handball that to Robert.
So the second case you're just talking about,
The Redeemer case.
yeah, why has that got any? Why does the finding in that case have any connection to religion? Is it not just simply a case that, by nature of the agreement, that I'll work for free, or I'll work and if you give me some money to feed me, then it's okay. But
Yeah.
There's no. I don't see why religion comes into
Religion
that.
as a factor became an issue, and Tom will correct me if I'm wrong. I certainly don't presume to have the detailed knowledge of it, but it arose because one of the arguments. Sorry.
Someone took the point about.
Someone took the point because the exemption within the Defamation Act was that you could only maintain certain causes of action if you had 10 or fewer employees. And the argument being raised as well by the defendant is, well, the plaintiff cannot maintain the cause of action because it's got 10 or more employees. And the argument in response is, well, no.
Servants of God.
They're servants of God, or they're volunteering, and they cannot be considered as employees, if you like, for the purposes of that section. Now, the court disposed of it by saying at a certain level that, well, look, the use of the word employ in that exemption is much broader than in an industrial sense. But let's look at the point anyway, because it's been raised. So in the context of these volunteers for in the services of the church, can they be regarded as being employed or having some employment contract in place, or is it there's no contract, and indeed it's some consensual arrangement whereby these individuals do the work? So it became a bit of a separate point. That
none of that analysis turns on the fact that it was volunteers in a religious organisation. It could have been volunteers at, I don't know, Happy Sunday.
The broader context, Bill, was that there was a prosecution under the award for back pay because they were all teachers employed in a registered school and qualified teachers. So if it had been a question of whether they were volunteers or not, I think they would have gone down. The fact that they were ministers of a church was the real X factor in that case.
So you're saying that the ministerial or the religious aspect of the relationship still played a part in determination of the rebuttable presumption?
It was the
lead part.
It was
volunteers was only a sub.
Yeah, but what I'm saying, like, so if you stripped out the fact that they were at a church, they would have gone down on the non-intention to create legal relation.
For an employer to run a defence saying, my teacher who I've engaged for the last 6 years under the award was really a volunteer the whole time, even though he's turning up from the hours of 5 days a week, etc., you would have gone down.
No, of course you're going to go down that point, but the way that this agreement was structured, if I understand, I mean, I haven't read the case, but is that you were working with no expectation of reward. If you were given a reward, then, well, that's all good, you can feed yourself tomorrow.
That's right.
But if you don't, well, there's no obligation to give you the reward or award, right? So then the argument that flows from that is, well, was there an intention to create legal relations if there was no expectation of any reward? And I don't see why that particular argument would turn on whether you're working for the Baptist Church or McDonald's, the Ronald McDonald's.
I just think after you're working for 6 years for someone regularly, as another employer, history militates against that notion. But anyway, that's a good answer, Brian.
all right.
There's a presumption that if you're working, you're working pursuant to you're employed and you're employed pursuant to a contract. The carve-out is in relation to either ministers of religion or people working for religious organisations where the presumption sometimes goes the other way, as it did in the Baptist Redeemer School case, but didn't in Ermogenous. Because if you look at Ermogenous, and it's spelled out in the paper, as the industrial magistrate found, all the indicia of employment on the various tests were made out. The only way out for the respondent in the High Court was if it could establish that there was no intention to create legal relationships, and they failed. Of course, in the cases that I want to deal with, which start at page 9, that wasn't a question, because in each case there was a contract of employment or a series of contracts of employment binding the rabbis. It's important to understand that both of those cases, that is the Gutnick and Bondi Mizrahi on the one hand, and in the matter of Southhead Synagogue on the other, involved Orthodox Jewish religious communities. The Orthodox Jewish community is not hierarchical. Each separate community can do what it likes, how it likes, subject only to the law of the land, and in some cases, if it's a religious community, religious law. Religious law yields to the law of the land, unlike Sharia law. And because individual communities can do what they like, and because it's not hierarchical, individual communities have to raise their own funds to operate their synagogues and whatever else they do. And one of the ways synagogues raise money is to charge members of the synagogue a membership fee. And people pay the fee and come along and worship in the synagogue and are ministered to by a rabbi. Now, if the rabbi is no good or past his use-by date, then if he remains there, the members tend to go elsewhere, and that puts the congregation in financial extremis. And if you can't get rid of the rabbi, it's a real problem. And that was the case both in the Gutnick case and in the Southhead Synagogue case. And I was involved in both of them at various points. Bilal was involved in the second one until the administrator was appointed, and when the administrator was appointed, our services were dispensed with, and our advice was thrown out the window, and it ended in tears. However, I digress. The issue in Gutnick was whether what happened was that the synagogue convened a extraordinary general meeting of its members with a view to making the rabbi redundant. And the rabbi rushed off to the Supreme Court and sought an injunction saying he had a contract which incorporated by implication a term known as hazaka, which effectively meant that he had the position for life, and therefore he couldn't be made redundant or dismissed other than in accordance with Orthodox Jewish law, and further, that any dispute between the congregation and he had to be determined by a religious court. He said both of those terms were implied. Because the congregation was an Orthodox Jewish congregation, it was a bit difficult for it to deny some of the propositions. But he had a contract which was made in 1987 for a term of 3 years, which contained a clause which expressly excluded hazaka, so that the congregation had cleverly said this concept of job for life, life tenure, it's not part of your contract, it's out the door, you can't rely on it. That was great, except that the contract came to an end and his employment continued. And the question was, did it continue under an exclusion of hazaka, or did it continue on the basis that the rabbi had hazaka? There's also, as part of Orthodox Jewish law, the concept that if you were there for more than 3 years, then there's an implication, without an exclusion, there's an implication that you are there for life. Indeed, there's a story, or I don't think it's anecdotal, I think it's actual. It's for real, where on the 364th day of the 3rd year, the president of a congregation said to the rabbi, "You've got to sign the contract for another 3-year term." And the rabbi said, yeah, next week. And the president said, no, next week you'll be out of a job unless you sign today. And he signed. So that's how it operates. Anyhow...
Wasn't there an express term that said that Jewish law applied? Didn't the contract make an express reference to it? You talked about implication. No, because the implication arose
from the... that was the position in the second case, in the Southhead Synagogue case. But the evidence that was before the court, given by the rabbi, who was regarded as an expert, unsurprisingly, was that in accordance with halacha, which is Jewish religious law, a rabbi's continued employment in the absence of a contract that's specifically expressed to be for a fixed term, and without any specific and express exclusion of hazaka contained in such a contract is sufficient to constitute creation of hazaka. So if you don't have the exclusion and there's no fixed term, then you're in. And that evidence was uncontradicted. The congregation couldn't contradict it because it's bound by Orthodox Jewish law. So the judge, Justice White, found that there was a serious question to be tried, that after the expiry of the 3-year contract, the employment of the rabbi continued without there being express exclusion, as was provided for in the earlier contract, and that's a serious question to be tried, that hazaka applies unless it's been expressly excluded. He also found that there was an implied term that there was a serious question that there was an implied term to the effect that hazaka applied to the plaintiff, because after the expiration of the contract, on a number of occasions, the plaintiff rabbi had insisted that he had the right to hazaka, and that position was not rejected by the board of the congregation, or alternatively it acquiesced or at least failed to reject the assertion, which raises a serious question. So he granted the injunction, and he also felt that there was a serious question as to whether the matter should be dealt with by a Jewish religious court. Again, the congregation couldn't say no, it shouldn't be, because there was evidence that Jewish religious law requires disputes between a rabbi and a congregation to be dealt with by a religious court, not the Supreme Court of New South Wales. So off the parties went to a religious court, and they got a decision from the London Beth Din, which is the court of the chief rabbi of the British Commonwealth.
And Goot managed to gather, and they didn't.
Yeah, but, and this is the point that Max came for, in paragraph 30 of the decision, the religious court cited an advice, a memorandum of advice by M.J. Kimber SC as to the calculation of what the plaintiff rabbi was entitled to
if he had tenure.
But importantly, and this is important, importantly, this religious court defined what hazaka, what this right was, and it was, and we've set it out in the paper, but the principle is that a rabbi has been appointed by a community should not have his employment with the community terminated save in exceptional circumstances such as misconduct or inability to fulfil the terms of his contract. The law of hazaka imposes a prohibition on the communal managers preventing them from dismissing the rabbi. It is to be distinguished, they said, from an obligation to employ and remunerate the rabbi indefinitely. And they went on to say that life tenure was different to hazaka, and that they said, we take life tenure in this context to mean some arrangement whereby the rabbi would be entitled to be paid until the age of 65. Further, there is a halakhic rule in a dispute as to the interpretation of a contract. The party claiming a benefit is at a disadvantage if the benefit is not clearly defined. This is not a contradiction of the concept of hazaka, which entitles a rabbi who is the incumbent of a synagogue to remain as rabbi of that synagogue even beyond the age of 65. However, as we noted, the concept of hazaka has nothing to do with financial entitlement and relates exclusively to the rabbi's right not to be usurped in his position by the appointment of another rabbi in his place. The concept of hazaka does not give a rabbi rights of remuneration. Now that's critical for consideration of the decision in the Southhead Synagogue case.
Robert, how did they come up with 65? Is that just a...
because they accepted that in Australia, retirement age is 65, and they gave him 15 years till 65.
But 65 seems to be by reference to hazaka.
No, wasn't.
Okay.
For life, according to hazaka,
Yeah.
but for him, because he said that
His dad had lived till he was 83.
Sorry?
And Goot said his dad had been a rabbi. And
Yeah, he was. But what it's complicated by this in this way that the London Beth Din accepted that there'd been some sort of an agreement where he'd be there until he was 65. They compensated him until he was 65. They didn't give him a lump sum payment calculated by M.J. Kimber SC. They discounted it heavily. Then they said, well, if the synagogue has to pay this money now, the synagogue will go broke, and maintaining a synagogue operationally is far more important than paying the rabbi. So put him on the drip, pay him per month until you've discharged the debt with an upfront payment at the outset. In Southhead Synagogue, the
before you go to the next case, did that ruling, which I've not read,
yes,
did that make sense? Was that consistent with earlier rulings in the context of Jewish law? Or was it a pragmatic one saying we can't go on with this? I had the impression that this was like holy writ, as it were, that once you got the gig, you held it and they paid you forever and a day. Was this pragmatism coming in?
Well, it's always difficult when a rabbi is a plaintiff in a rabbinic court, with his brothers sitting in judgment. They listened very politely to our arguments, and they then wrote a judgment which didn't have much to do with the case that was run before them. Anyhow.
Can I just ask one further
Yep.
question? Leaving aside the reasoning when
Yes.
it got to the religious court, the avenue, to take the point before, the avenue for getting to the religious court
It's simply
was simply
conventional
contract
application
law,
of
which
an
then gets
implied
you into
term.
another arena where
That's
things
right.
happen.
That's
what
right,
happened.
conventional. And that was made clear by Brereton in the next case.
Sorry, can I ask
But-
one further?
Yep.
Just on that. Well, it's the first time I've come, so, you know.
Yeah, no, that's all right.
I'll tick the box.
Yeah, but can the minutes record that next time, no questions from him? Yeah,
Well, I guess my question is, so what you've got here is the Australian courts accepting that a religious court can make a determination about this particular area.
yes,
So then you come across to more contentious, let's call it religious concepts, i.e. Sharia law.
yes.
And how are the Australian courts going to treat this type of sort of ability to step outside of what we would consider the Australian sort of jurisdiction into?
It'll depend on the
exclusive
contract.
Religious jurisdiction.
It'll depend on the contract and the facts, and Brereton deals with it. Just bear with me. Yes. Brereton said, and it's at the bottom 13, having regard, and this is critical, having regard to the proposition that parties to a contract governed by Australian law can incorporate into the contract as terms of the contract provisions of another system of law, including Jewish law, in the circumstances he had no difficulty in relying on Orthodox Jewish law as part of the contractual framework, and its content, at least for relevant purposes, was not considered by him to be controversial, unclear or uncertain. So it was pretty straightforward. Question the parties had, as he found, agreed in their contract of employment that Jewish religious law would govern the interpretation of the contract, and that's what he required the parties to do, because, as I will explain, he found that there was he had evidence before him that a subset of Jewish religious law was the concept of hazaka. But let me go to the case.
Sorry, Robert, but just one thing.
Yep.
To take up this point, which is obviously interesting.
Yeah.
If it wasn't Jewish law, but Sharia law,
Yes.
is there room for the notion that the assumption that Brereton was able to make wouldn't be
Correct.
the assumption that would be made,
Correct.
but that the matter would be dealt with by that part of our law, which is to the effect that contracts may be against public policy, so that the difference may lie in the application of our civil law in relation, and so that a result different to that which Brereton came up with in that case might be on the cards.
Yes.
Because
that
of retention.
Yeah, because he
Well,
qualified
because
it.
of the laws relating to contractual public policy.
Now, the
And-
tension between that and Sharia law.
Correct.
It may be. I don't know. I'm not an expert on Sharia law, but
Well, but how do you know there's a conflict? I mean,
Wills is
what
one
the
example
Australian-
where often wills will make reference to Sharia requirements, and as a matter of course that has been applied and recognised.
What's interesting here, sorry,
yeah,
I
no.
don't know, but here they're able to go off to, like, let's call it a court that dealt with Jewish law, and
Yes.
they were presumed competent in dealing with that. I mean, like, but what didn't happen was an Australian court interpreting what Jewish law was in the court.
Yes, it did.
White.
Yes, it did. Yes, it did. Yes, it did.
Okay.
But if it interpreted Sharia law and it came up with the version that one of the parties was going to have their hand cut off as a result
Yes.
of the outcome, then that would play into a public policy
It may.
outcome, in which case you'd say, look, the parties may have intended this result, but the court isn't going to give effect to that result.
Or Indigenous law.
And its content, I mean,
Exactly, or
yes.
Indigenous law where you get spared.
but Brereton said, and its content, meaning the imported law or the legal framework, at least for relevant purposes, is not controversial, unclear, or uncertain. Well, if it was, it'd be there may be a different result.
Okay.
He covered it. Okay, so what happened in South Head Synagogue was that the synagogue was facing financial pressures because the rabbi had been there for a long time. He was 62, applying the London Beth Din standard. He had 3 years to go. People were voting with their feet, so they appointed an administrator, which the earlier synagogue had not. The synagogue in the earlier case had not done, and the administrator decided to terminate the rabbi for redundancy and misconduct.
How does a rabbi become
In the alternative.
Yeah, and then there was a real case of misconduct, but they abandoned the misconduct. Misconduct, those of you who have been listening, was one of the grounds that the London Beth Din said cancels the Hazaka. Anyhow,
You advise them to run redundancy? Was
No.
that your right?
no, misconduct, yes, redundancy, no. Anyhow, but then the administrator decided to approach the court for declarations. The rabbi then filed a cross summons seeking declarations that he was employed, that they couldn't dismiss him, and that he had hazaka and seeking an injunction and the rest of it. And he elected to maintain the employment and the contract. So his contract, which also had it had lapsed and be renewed, but part of it was retained, and that was that two clauses: one, that the relationship between the rabbi and the congregation shall be defined in accordance with halacha, which is Orthodox Jewish religious law. So that was a contractual term. And secondly, any irreconcilable disputes between the rabbi and the congregation shall be decided according to halacha, and the judges are to be decided by the chief rabbi of Israel or by mutual agreement between the rabbi and the board of management, so that you had a dispute resolution proceeding agreed and Jewish religious law all over this contract. He determined, that's Brereton, that the issues were the administrators entitled to terminate the rabbi's employment other than pursuant to an judgment by a religious court in accordance with Orthodox Jewish law, that it was justified on a ground recognised by the usages, customs, practice and traditions of Judaism, if not the dismissal was wrongful, and if it was wrongful, the rabbi having elected to affirm the contract should the court grant an injunction. Now, he had expert evidence before him, which expert evidence was unchallenged and uncontradicted, that halacha denotes Orthodox Jewish law and jurisprudence, that halacha includes laws that regulate the legal relationship between a rabbi and a synagogue, one of which provides that any dispute between a synagogue and its rabbi, unless resolved by agreement, must be adjudicated before a court of Jewish law, same as in Gutnik. And another aspect of halacha, compendiously known as hazaka, is that a rabbi who has been appointed by a congregation, however constituted, has life tenure in that he is entitled to be and remain employed in that position with all its rights, privileges and benefits for the rest of his life, and cannot have his appointment terminated except by agreement or pursuant to a decision of a properly constituted religious court.
That's life tenure.
It's life tenure, paid for.
Paid life.
Yeah, paid life tenure, and quite different, quite distinct from what the London Beth Din described it as, but again, not put before him. And also excludes misconduct as a ground of termination as an exemption of hazaka. So,
You mean expressly excluded? Or?
No, because his definition, the definition he relied on, the expert evidence he had before him, said that it could only be terminated by agreement or pursuant to a decision of a Jewish court, not by misconduct. Yeah, contrary to what the London Beth Din said in Goot. And of course, the synagogue had a constitution which, as Brereton said, expressly applied the customs and observances of Orthodox Judaism to their activities, endeavours, thought processes and the like, which meant that the synagogue, the halacha was coextensive with the obligations under the Memorandum and Articles of the Memorandum of Association of the Synagogue. So he went on to say that in those circumstances it's inconceivable, in light of the objects of the company, the purpose and terms of the contract, and the evidence that halacha regulates inter alia the legal relationship between a rabbi and a synagogue, and that obedience to it is an inviolable religious obligation, that the parties to the contract did not intend that hazaka, life tenure, be a term of the contract. Game, set and match. The only question then was, and then he made his comment about importation of the term, and alternatively it was an implied term of the contract, and the only question was whether an injunction should lie, and he had little difficulty in injuncting the administrator from acting further. So again, it was the application of conventional legal principles to contract law to either incorporate aspects of Jewish religious law or to imply their application in the circumstances and on the facts. What it means is that I predict it will be the last of that sort of case, because by now congregations are redoing their contracts, excluding hazaka.
It sounds like the London Beth Din were out of step, in the sense that there was an intention that not only would you have, that you couldn't be disturbed as a rabbi, but you were supposed to be looked after financially. It goes hand in hand. There's no point being the rabbi if you're not going to be free to live by. That was the whole idea, that I'm going to serve the community and you're going to give me a stipend and look after me.
Yeah, no, the whole idea was that,
Yeah, but this was reflected in the thinking
Yeah,
of that contract, and the second contract, in clear terms of what we intend here.
Yes.
Is that you are in the chair and you're going to be there till you die, pal.
Yeah, well...
Provided you do a good job.
Well, no,
Yeah,
that's not
no, look, I don't think, I think that the London Beth Din was applying a traditional concept to the reality of life in a religious community in the 21st century, where no question of a stipend, there's significant remuneration, especially when you have regard to the Fringe Benefits Tax Amendment Act, which enables ministers of religion to be paid almost entirely by fringe benefits, and for that not to be taxed, so that you just package it and give them $10,000 income and the rest is benefits. So, you know, it can be in the case, I won't go into detail, I think it's published actually in the decision of Brereton. The rabbi at Southhead Synagogue was on a very substantial packet, and if it was for life, as it is,
So they were
they're in deep
responding to
shit.
the reality that the rabbi was partly
Yeah.
by that the congregation moved away.
Yeah.
And they had to respond to that practically.
That's
the
right.
reality.
Well, how easy is it for them is just to shut down one congregation and open another one?
It's difficult because that's what they've tried to do. They've appointed a liquidator at Southhead.
They own a synagogue, presumably, so
Sorry?
they own a synagogue.
Oh, they own a very substantial asset, and it's now being operated by a different group, but with the same members.
Is that the practical answer, the way you shut one down and open another? Transfer
It
out?
might be. It might be.
Can I ask, the question is raised, and it's more general than the religious question. But going back to the Goot idea, if you have it, and this comes up too often and it's troubling, you have an express contract that knocks out Hazaka.
Yes. Yes.
Yeah, sort of.
So the parties, when they entered into their relationship, expressly, their intention was to exclude us.
Yes.
Wasn't to apply.
Yes.
And yet, when the term of the contract runs out, then all of a sudden they say, oh, well, it doesn't apply anymore. Like, why would
No, because there was some
Only a
intervening
serious
act, and it's
question.
dealt with in the facts. There was a memorandum which said there will be Hazaka, but it was never signed, but or put to the community, congregation, etc. And then there was a conversation, and it was messy.
more evidence of an intention for it to
Yeah.
continue.
Which the court said would only found a serious question, but the London Beth Din went further and said, no, you guys gave him Hazaka.
Robert, were you guys going to say something about the...
I was. I think Bilal was going to say most. I just wanted to make a point that this issue arises, as I said earlier, substantially because those advocating a no vote raise a question about religious freedom post the change to the Marriage Act.
Yep.
And the paper deals with some aspects of religious freedom in this country, but having regard to Tom's point about section 116 of the Constitution, as I understand it, the people who are worried about this issue say, for example, Gerard Henderson in his most recent column, point to the New Zealand Bill of Rights, sections 13, 14 and 15, which provide much more comprehensive guarantees of religious freedom, including that every person has the right to manifest that person's religion or belief in worship, observance, practice or teaching, either individually or in community of others, and either in public or in private, which would, if
Does
that...
mean you can discriminate?
Yes, you can, but you can now. Religious institutions, as Bilal will explain, religious institutions, including schools, can discriminate in certain circumstances. But it would mean, if Section 15 of the New Zealand Bill of Rights were enacted here, it would mean that you couldn't fall foul by teaching that non-same-sex marriage, conventional marriage, is the only marriage that should be recognised.
Yeah, so what we want to do was just to sort of try and bring it back to a more topical issue, was to look at that intersection in terms of the same-sex marriage debate and religious freedom, and then in applying sort of discrimination laws, and there's a couple of points really. One is, well, what's the current landscape? So what are the current existing protections, which in Robert's adverted to in a broad sense? But then secondly, now there's been discussion of enacting assuming it all goes down the path of yes, enacting legislation and then encoding within that certain protections, that raises a further question about, well, even if that's done at a federal level, how does that impact and then interrelate, operate vis-a-vis the state provisions? And you know, is there some level of, will there be some inconsistency or overriding or not, or can the state legislations continue to operate in as much as they prohibit discrimination in certain scenarios which aren't captured by the existing exemptions? So there are those types of questions which do arise, but what we did do as an exercise was just look at some of the discrimination laws in place and identify the exemptions in particular at the Commonwealth level, the Sex Discrimination Act, for instance, that's Section 37, which provides exemptions relating to discrimination in the workplace, and also in certain other areas in respect of ordination, appointment of priests, training or education of persons seeking ordination, appointment, selection of appointment of persons to perform duties and functions for purposes of or in connection with any religious observance or practice, any other act or practice of a body established for religious purposes, being an act or practice that conforms to the doctrines, tenets, beliefs of that religion or is necessary to avoid injury to the religious susceptibilities of adherents of that religion.